Hello, my name is Benjamin Hart. I'm an American attorney and the managing director of Integrity Legal here in Bangkok, Thailand. For folks who've been asking about my hair, I've actually gotten a couple of emails. They're like, hey, what's going on, man? You growing out your hair? You going long? Hey, I've actually been playing a little game with my kid the last couple of weeks where I sort of will be sitting there talking to her and I'll say, is my hair too long? She'll turn around and look at me and she'll say, no, but don't let it grow much more. But then that's been going on for like 2 weeks, and I was kind of joking with her because I don't know if she knows that hair grows or whatever. Obviously she does. But I was sitting there having lunch yesterday, though, and she looked up at me unprompted and said, you're starting to look like a girl. So probably time for a haircut. So yeah, you've been heard. But yeah, I have been playing a little game with my daughter. But the show must go on, so I got the hair I got today. That being said, I actually thought of making this video, and I want to be clear when I say fatal flaw, I'm not saying that the common law is inherently flawed or something like that, but I was watching another YouTube channel here called the Solari Report, which is put on by a lady named Catherine Austin Fitz, but there's another gentleman on there that tends to collaborate with her rather frequently, a gentleman by the name of John Titus, who also has, I believe, another channel called Best Evidence. He is an American attorney, I believe, if I'm not mistaken. At least he's legally trained. And I have enjoyed his work for some time, Ms. Fitz as well. But they were recently in a recent podcast, whatever you want to call it, interview. And I was listening to it, and he brought up a really good point. And it's something I've tried to articulate for years, and I haven't been able to articulate it in the right words. And Mr. Titus just in an instant, in like one sentence, articulated something that I've been trying to put into words for a long time. So on a certain level, I'm kind of jealous of him. But for those who are unaware, I have studied the civil law here in Thailand and how it compares. It's called comparative law. How it compares to the notions of common law, precedent, stare decisis, many of the equity that we utilize in both the Westminster as well as the American common law system. I've looked at all of these things, and I like to compare them to just a general civil law system and the Thai legal system specifically, because as I've discussed in other videos, the Thai legal system is in and of itself unique. It's civil law, but the Thais adopted things from many different countries, concepts from many different countries. In many ways, they kind of adopted certain British mercantilist legal structures. There's some American legal structures that are even sort of thrown into the mix that is Thai. If anything, Thailand's legal system is like a gumbo, if you will, of other countries' sort of concepts and legal philosophies. And then on top of it, they place their own legal philosophy on it, which, as we've discussed, things like the Three Seals Law predate what we call the civil law here in Thailand by many centuries, in fact, in certain cases with some of these legal concepts. But a civil law body of law was brought in as the unequal treaties were wound down, as we've discussed in other videos, especially videos I've made in the past regarding Francis Bose Sayer, who was an American who acted as an advisor to the late King Rama VI, who actually was instrumental in getting many of those unequal treaties concluded. They basically wound them down in the aftermath of the First World War, which was a major benefit for Thailand. But one of the things that arose out of that, the upshot, if you will, was effectively the creation of what we call the Civil and Commercial Code, or this body of civil law that most foreigners will oftentimes operate under here in Thailand. And so circling back to what we're talking about in this video, I was watching that Solari report, and this is the reason for the thumbnail, which the thumbnail is actually Hannibal, I about said Hannibal Lecter, no, Hannibal Barca. He was the late general of, at the time, if I'm not mistaken, he was the Carthaginian general who invaded Rome. Basically came up over the Alps with a bunch of elephants, came back, that's sort of the legend, but came up over the Alps with his army, and the elephants were in it, and surprised Rome, basically sacked many, many armies in the field, but he could never capture Rome. And if you read Roman history, they'll tell you about a gentleman named Fabius. He came in, he was one of the consuls. He basically came up with what's now referred to as the Fabian strategy of sort of waiting it out, going into the hinterland, not engaging, the enemy, and just sort of letting them deplete over time. And that is, in fact, kind of what happened to Hannibal. Hannibal is very odd. If you study military tactics and history and strategy, Hannibal is kind of a mixed bag. He's almost a tragic figure in terms of military history because he was amazing, but he ultimately lost. He's very Napoleonic in that way. And the person that beat him eventually, Scipio Africanus, on the fields of Zama, beat him in much the same way that, hundreds, thousands of years later, Wellington would beat Napoleon, which is basically he mimicked him. He learned how he operated, figured out how he thought, and then figured out how to beat it. That was basically what Scipio Africanus did, because Hannibal was so brilliant, which again circles us back to what we're talking about here in the thumbnail, which is a tactical win and a strategic loss, and what I would call the quote-unquote fatal flaw of the common law. And that is, the common law constantly ends up in this feedback loop, if you will, of tactical wins and overall strategic losses. What am I talking about? Well, in our system, because again, it's adversarial too, and this is very different than the Thai system or the civil law system generally. Generally speaking, the civil law does not use precedent per se, although in the European system now, through commentaries and things, it's my understanding effectively it kind of does bring forth these legal principles in a similar manner to the use of stare decisis or precedent in a common law context. But let's set that aside. As a general rule, the doctrine of codification and things are the bedrocks to the civil law, less the notion of stare decisis, or in Latin, let the decision stand. Basically the notion of common law precedent. Prior cases, the holdings can dictate the thinking in later analysis, in later cases. And while this can create certainty, it is also, as Mr. Titus points out in that clip, and I'll put a link in the description below to the clip where you can see what he's talking about in context, it is something of a fatal flaw. And in many ways it is, because we put our best minds, legal minds, for example, in the context of cases where something may challenge a fundamental liberty of the United States, but that fundamental liberty enshrined in the Constitution may, for example, states' rights was an example of this, which unfortunately state sovereignty was utilized a great deal, especially in the first half of the 20th century, to basically discriminate against folks based on race. Okay, the federal government steps in, which under that scenario was sort of warranted in order to protect the liberty of individuals. That said, 9 times out of 10, the federal government stepping in over the states is actually detrimental to one's individual liberty. That's just the way that it sort of works, practically, okay? The point I'm trying to make is, in those civil rights cases, it's an example of this sort of fatal flaw where you're having to use the best legal minds to go after certain concepts that perhaps are things you would want to preserve most of the time, but in these limited instances are actually negative. The problem with that is the case law sets a precedent that then can operate against the underlying liberty on an ongoing basis. And I think that this is the fatal flaw that Mr. Titus is trying to point out. Also, the other thing is candidly, I've talked about this a lot in my own study of comparative law over the years, which is, just the fundamental notion that why does Hadley versus Baxendale still control? I mean, again, I understand it from the concept of we want some notion of certainty, but to rigidly control is like a dead hand from the grave, in my opinion, in a legal sense. We're allowing sort of the dead to dictate ongoing legal theory. It's not the greatest way to operate under certain circumstances. Again, especially where technology changes so much that the law can barely keep up. Now, I don't know what the right answer is, and I'm not in favor of upending the common law. In many ways, the common law is very, very useful. But one fatal flaw that is not oftentimes pointed out within the common law is this notion that, one, you will oftentimes be attacking good things for limited reasons, for in cases involving a very unique set of circumstances. That's problematic in its own right. And then on top of it, in a scenario where you can effectively gain where you can get a tactical win while having a strategic loss, is one of these situations wherein you take something to court to fight in your limited case, but in reality you're setting a precedent that goes against broader liberty. That's the fatal flaw. That's problematic. An example of this phenomenon, although not in the common law context, for example, in the Western America, but here in Thailand recently, to my mind, is this whole tax debate. The tax debate itself. If we'd have never been talking about this, I expect as a practical matter, very little would have ever changed. But the fact that everybody got all up in arms and started having a big, not up in arms, but got all freaked out and then started sort of demanding free advice, it resulted in these folks coming out, basically the stamp pimps coming out and all saying, oh no, y'all owe taxes, or y'all got to go file, or y'all got to go do something where you pay us some money. Okay, but think about it. Having the underlying debate, just having that is kind of a loss in and of itself when you compare it to the way things were working before, which was nobody really cared about any of this. There was no discussion. Again, point I'm trying to, and that is to my mind, again, a sort of fatal flaw of the American legal system or the Western, the common law legal system. Again, very different from the Thai legal system because it's adversarial. We have this paradigm where we need to get into an argument to hash this out. Well, in a civil law system, that may not be a good thing, as we have seen throughout this tax debate. Frankly, all it's done is cause a lot of consternation. I don't think it's going to be any major benefit to Thailand in terms of any accrued revenue, because anybody that would owe anything is just going to run out of here before the filing deadline. And anybody that doesn't is just going to end up going into the system and wasting a bunch of public time and resources in terms of public man hours, public funds to process all these people through who don't owe anything to begin with. And again, that adversarial nature of our legal system in the West that we oftentimes carry with us everywhere we go, again, that desire to get into an immediate adversarial situation and then engage in this sort of precedent-setting discourse, it has benefits, but it is not 100% purely positive. And that is the point I'm trying to bring up with this video. And I really, really must thank Mr. Titus for stating that so concisely and eloquently, because I've been looking for a way to describe that scenario for years and just have not been able to figure out a way to articulate it. And again, I think it's best put, this flaw in the common law system, if you will, which again is not a reason to upend it. It's just something to have in the back of your mind when you're doing analysis of comparative law or just operating practically here in Thailand and you have to deal with the legal system and you start saying, oh, well, it's better wherever I'm from. Well, it may or may not be. But again, summing up, Mr. Titus's quote that, again, attack the tactical win and the strategic loss. Yeah, that is a fatal flaw to my mind of the common law. It's something to bear in mind, and I think it provides some insight for expats here in the Kingdom of Thailand.